third debate. With the nomination and appointment of Neil Gorsuch to the Supreme Court, a national debate reignited over originalism, the judicial philosophy that interpretation of the statutory and constitutional text should adhere to the original public meaning fixed at the time it was enacted versus and compared to stare decisis, Latin for let it stand, the judicial philosophy that supports following Supreme Court precedents even when they conflict with the original text. Our final debate is here to tackle that issue in the bankruptcy context. The third resolution is, despite stare decisis, wrongly decided case like Dusnip should be overturned by the Supreme Court. Our third debate speakers are Ilya Somin and Professor Bruce Markell. Taking the pro side is Professor Somin. Professor Somin is a professor of law at George Mason Antonin Scalia Law School. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. In addition to numerous scholarly journals, Professor Somin has published numerous articles in the popular press, and in his spare time has written a number of books, including in 2016, While Smaller Government is Smarter. Taking the con side is Professor Bruce Markell. While this is not Professor Markell's first trip to our rodeo up here at the Great Debate stage, and while I think most of you know him from his visits to regional conferences and elsewhere, I will briefly note for the uninitiated some background. Professor Markell is a professor at Northwestern University School of Law in Chicago, and before that, he was a bankruptcy judge in the U.S. District of Nevada for 9 years. In his still earlier life, he was a partner at Sidley Austin in Los Angeles, and he began before that in Los Angeles with then Judge Anthony M. Kennedy of the who was then at the Court of Appeals for the Ninth Circuit. The last credential seems particularly relevant given the Supreme Court's current makeup and the focus of our debate. He also contributes to Collier on Bankruptcy, is the author of numerous articles and 4 textbooks, and is a fellow of the American College of Bankruptcy. Thank you for joining us today. We are honored to have you both. Professor Somin, I will turn to you to begin our debate.
Thank you. So having written a book called Democracy and Political Ignorance, I should probably start out by acknowledging the limits of my own knowledge here. I'm not a bankruptcy expert, therefore I don't know if Dusnip was wrongly decided. Even if it was wrongly decided, I don't know for sure whether it should be overturned 25 years later. What I do know is that at least as a general rule, courts should be very reluctant to place their own mistaken past decisions ahead of the original meaning of the Constitution, or in many cases also of statutes. And I'll start off with a very basic point. Judges take an oath to uphold the Constitution. They don't take an oath to uphold their own past precedents. And there is a difference between the two. It is sometimes said that the Constitution is just whatever the judges say it is, but we all know that isn't true. The reason why we know that is because we all, in our minds, have a list of court decisions where we think that judges got it wrong. And we couldn't coherently say that if we thought that the Constitution, or the laws for that matter, are just whatever the judges say they are, because then it would be completely incoherent and meaningless to say that they got something wrong. As soon as they made a decision, we would have to conclude that by virtue of the fact they made it, it must be right. Moreover, at least in the constitutional field, there are actually huge costs to wrong decisions. The U.S. Constitution is one of the most difficult to amend in the entire world, so if judges can't overrule their flawed past precedents, we might be stuck with those precedents for decades or centuries, or perhaps forever. And when we are stuck with bad precedents, that can lead to terrible results that undermine vital constitutional rights or vital limitations limitations on government power. There are many examples of this throughout history. I will just mention a couple. Obviously, the history of Jim Crow segregation, the history of severe violations of freedom of speech, and there are quite a few other examples as well. Now, it is not my view that even in the constitutional area, courts should always overrule all wrong precedents no matter what. There may be some precedents which are so well established and have such great reliance interest behind them that the costs of overruling them are just too high, or alternatively, it just isn't politically feasible. The policy behind the precedent is so well entrenched that if the courts were to overrule it, the rest of the political system just wouldn't obey them. There are going to be some situations like that. So, for example, if you believe, as some scholars do, that the 1870s decisions upholding the constitutionality of paper money were incorrect as a matter of original meaning, it probably is too late to get rid of them today. The costs would be too high. But I think exceptions like that aside, as a general rule, we should get rid of wrongly decided constitutional precedents. Things are more complicated in the statutory area. Obviously, in the statutory area, wrong precedents are easier to change through the political process. Congress or a state legislature can enact a new law, and also they're less likely to involve vital constitutional principles or limits on government power. So the costs of these bad decisions are lower. Nonetheless, with statutes, as with the Constitution, it's ultimately the text of the law that judges have a duty to uphold. So they should at least, in many cases, be willing to overrule or modify wrongly decided cases. And there are going to be also some situations where there are actually severe costs to perpetuating wrong decisions, even in a statutory area. It is, in general, going to be the case, however, that there will be a tougher trade-off with respect to statutes than with the Constitution. Here, there may be reliance interests that are significant, and maybe they carry more weight than in the constitutional area because there are other alternative ways to fix this. That said, even though there might be more room, I think, for stare decisis in the statutory area, there shouldn't be anything like infinite room. And in some instances, even if there are reliance interests which counsel against completely overruling a bad precedent, you should still, in the courts, look for ways to limit the scope of that precedent, and maybe even in some instances to deal with reliance interests by overruling the bad precedent prospectively, but not retrospectively. And there are certainly examples of this in both the statutory and constitutional area. So the bottom line is this: courts make mistakes. When they make mistakes, those errors can be really costly, and therefore courts, where possible, should try to fix their past mistakes, not perpetuate them. Thank you.
Thank you, Professor. Professor Markell.
Thank you. And I'd like to thank the ABI. Thank you, Doug, for the opportunity to do the debate. Professor Somin started with a disclaimer that he doesn't know bankruptcy law. I don't know con law. Actually, I think it's aptly named, but I want to talk about stare decisis, and I want to try and make 3 points. First, I think stare decisis, as we know it generally, promotes stability, without which many of the reliance interests that Professor Somin talks about cannot develop. It promotes reliance on those so that lawyers can do what they are paid to do in terms of inform their clients as to the effect of a statute on their lives. That in turn makes the process more efficient. It cautions judges to craft their opinions in such a way that there are no unintended consequences. It is a pressure from the outside to get it right that is not necessarily present if in fact it's an open field day with respect to whether a decision is correct or not. The second point I want to make is a point I think that Professor Somin concedes, which is if in fact in the area of bankruptcy court or courts get it wrong, it's easy to correct through Congress. They created the statute. If they create the problem, they're the one to fix it. Finally, I'd like to focus the debate on where I think it probably should be, which is that everyone acknowledges, and it's hard to debate the point, that you should get rid of bad decisions. The whole point, though, of stare decisis is to keep some bad decisions, because good decisions don't need a rule of law to support them. We need stare decisis because there's a countervailing policy with respect to the stability and the efficiency of the court system. So in terms of starting at first, I was a little bit flat-footed when I heard the topic of the debate. Stare decisis is pretty old. You can go back to 1545 in the time of Henry VI and find judges talking, and I'm paraphrasing now, that you should not kind of vary from the statutes, because then what would the apprentices, then the lawyers to be in what passed for schooling then how would they ever trust what the courts have written if they know that it can be changed by an argument in the next time? From 1454 to the time of Blackstone, we have a development of precedent, and to the extent that someone looks at stare decisis or precedent and says, well, words should have the meaning of the time that they were adopted, Blackstone has a very strong support for stare decisis in his work at that time, and that's what we took into this country in terms of kind of going forward. Now, I should also probably, the point is all good debaters try to do, define kind of really what I'm talking about. When I'm talking about stare decisis, I'm talking about what some scholars refer to as horizontal stare decisis. That is to say, if one court can decide it, a lower court's bound by it. That's not what I'm talking about. That's vertical. Horizontal is when the same issue comes to a court and with the notion that you may have gotten it wrong last time. No notion of stare decisis is so absolute that it doesn't allow, in certain cases, for revision. Indeed, for the students of history, the English House of Lords from 1896 to 1960, actually in 1897 to 1966, actually did have a rule that they could not overturn a decision. Stare decisis was absolute. That didn't work. We, in America, have always been more pragmatic, and we have, and you can see in our history, that stare decisis is the main driver, but there is always the possibility of revision for, as the court has said, appropriate reasons. So the pressure that we have when we take a look at stare decisis is the pressure to get things right. And if they don't get things right, then the issue comes, well, when do we change it? Well, no less an authority than Justice Brandeis has said that really stare decisis, and I'm paraphrasing here a little bit, is wise policy, because it's oftentimes more important to get a settled rule of applicable law than it is to get that rule right. As bankruptcy lawyers, we know that. Lawyers adapt. They're smart. We can figure out when cases may not go the right way and how to advise our clients appropriately. And especially in cases like Dusnip, I also will call into question the basic notion that it was wrongly decided. Although I've been on record saying I don't like Dusnip, and I think a whole group of people who like statutory interpretation may call it into question, there is a group of scholars and lawyers who say, Dusnip follows the congressional policy of not allowing secured claims to be destroyed in bankruptcy absent the reorganization provisions. They ride through. 506D was intended to do that, and indeed, if you look at the legislative history, it's easy to have that position. So in terms of stare decisis, it's long-standing. It promotes stability. It promotes reliance. It has escape valves. I think we should think long and hard before we reject it.
Thank you, Professor. Professor, your rebuttal.
Yeah. So I'd like to focus on two main points that were just raised in what you just heard. First, the issue of stability. Yes, there is some value to stability, particularly when the rule that is stabilized is actually a good one. On the other hand, if you have a stably bad rule, that can actually be a very bad thing, especially if it lasts for a long time and becomes deeply rooted. There are many such examples in our history. I already mentioned one, the rules of segregation under Jim Crow. For many decades, they were stable and instituted and established, and the fact that they were stable and deep-rooted actually just increased the harm that they caused. So I think it's fine to make stability the prime virtue that we strive for in areas of law where the substantive rule doesn't matter. All that really matters is we have some clear rule, like whether you drive on the right or whether you drive on the left. Doesn't really matter that much which one. What matters is that we have a clear rule that is stable. But in many areas of law, particularly in constitutional law, but also I think in some areas of statutory law as well, the substance of the rules matters enormously, and getting them stably wrong just makes the situation even worse. It is true that there's a long history of stare decisis. There's also a long history of overturning bad past decisions. So the question is, what should be the trade-off between these two? And to my mind, the more important the substantive rule, the more we should be unwilling to keep a bad rule in place just because of stare decisis considerations. Finally, on statutes versus the Constitution, it is true that it's easier to change a bad statutory decision through the legislature, but often it's not that easy, particularly at the federal level, where you have bicameralism and you also have the presidential veto and the like, and you have a lot of gridlock. While it's reasonable to leave more room for stare decisis in the statutory field than in the constitutional field, the fact that it's easier to correct mistakes through the legislative process, we should not confuse that with it actually being very easy and simple. And on that note, I'm happy to conclude and rest my case.
Thank you, Professor. Professor Markell.
Thank you. 2 points. First, with respect to the constitutional issue, there are some constitutional issues in bankruptcy. Article 1, Section 8, Clause 4 says Congress shall have the power to enact uniform law on the subject of bankruptcies throughout the United States. If Professor Somin would have his way, most of you would be out of a job. Why? Well, there's a very good argument at the time of the adoption of the Constitution. Bankruptcy meant liquidation, didn't mean reorganization. And indeed, it wasn't until 1929, not in a court opinion, but in the Jackson report issued in that year, that finally put to rest a lot of the arguments that you shouldn't keep bringing up the notion that insolvency laws work within the power of the bankruptcy clause. Similarly, do we really want to reopen the uniformity debate? Do we really want to call into question the status of the U.S. trustee because they don't operate in Alabama and North Carolina? And finally, on that point, do we really want to go through the Stern, Arkinson wellness decisions again of the last couple years just because someone thinks that they're wrong? I think not. Last year or 2 years ago in Kimball versus Marvel Entertainment, Justice Kagan said that respecting stare decisis means sticking to some wrong decisions. I think that's a fairly accurate statement. You don't need a doctrine, as I said before, to promote decisions that can stand on their own. And I'm reminded in this respect of the flexibility, the plasticity of the notion that it's a wrong decision or a right decision. Who makes that call? Is it cabin to a particular area in time? I'm reminded of the words in a great movie, A Man from All Season. Thomas More is having a debate about the devil. And the opponent, when Roper says, I would take away all the laws to get at the devil. And Sir Thomas More looks at him and says, you would do that? He said, yes, to get at the devil, I would do anything necessary. He says, well, then what do you do when you finally get to the devil and the devil turns on you and comes after you? What will you hide behind? The devil here is the notion that there are correctly decided decisions. If we get rid of stare decisis, what are we going to do when, in fact, a new generation occurs that sees things differently? Stare decisis promotes stability. Stability is the essence of what we do. And with that, I rest my case.
Thank you. Thank you both. Poll.abi.org. Poll.abi.org. The question is, despite stare decisis, wrongly decided cases like Dewsnip should be overturned by the Supreme Court. Wrongly decided cases like Dewsnip should be overturned by the Supreme Court. Agree strongly, agree somewhat, disagree somewhat, disagree strongly. Please vote. Okay, guys, this is a nail biter. Everybody vote.
This is like Chicago.
I'll give you your iPhone back. Okay. Kareem. 45 agree. 43 disagree. 43, 46, 43, 50, 52, sorry. 46 to 52. Agree. The disagreements seem to have it. Great debate. Thank you so much for coming. Thank you. Okay, all. That concludes our great debates this morning. You have a 18-minute break until the session start. Please check the ABI app for the programs, and thank you for all coming.